Please. Hey! All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone, and welcome to the Appeals Court. My name is Peter Sachs. To my right, your left is Justice Rachel Hershfang. To my left, your right is Justice Gloria Tan. Will be your panel for the 4 cases we're hearing this morning. If you've been to the Appeals Court before, you know the light turns green. You've ordinarily got 15 minutes. When it turns yellow, that's 90 seconds left, and when it turns red, we'll ask you to finish your sentence. We have read the briefs. We've read the record. We understand the factual and procedural background of your cases, so I would just encourage everyone, when you get your time to argue, to make the best of it. Go right to the heart of your argument. We don't need a background on the facts or the procedural posture. I will say that in the first case, the appellee, Mr. NOYES, has not filed a brief. We will permit you to, ordinarily, when you don't file a brief, there's no obligation that we hear an argument. We'll allow you to argue for 7.5 minutes this morning, which is half of the usual time. So with that, I'll call the first case, 24P606, NOYES versus Mancuso.
Good morning, and if it pleases the court, my name is Mark Papirio, representing the appellant, Maria Mancuso. I wanted to start with the my argument that it was error to award the father sole custody, starting with the father actively suffering from depression. This was not given anywhere near enough credence by the court. It affected the child in several different ways. First of all, I wanted to address the fact that the judge, I also contest this finding that the trial court did not find, did not hear evidence of a clinical finding of depression. However, Mr. NOYES conceded depression. His mother testified that he was suffering from depression.
Is that a concession?
Excuse me?
Is that a concession?
It is, Your Honor. He challenged his mother's assertion that he was depressed, and she said, "You yourself have told me that.
Right.
You yourself have told me that you're depressed."
Does he? I mean, number one, is that a clinical diagnosis?
It's
which
not,
is
Your
what
Honor.
the finding. All right. And number two, yes, his own witness said he said that, but does that constitute a concession by him?
I think it does, Your Honor. And if you look at what is going on in the case.
Well, in what way does it?
That's where I'm going, Your Honor. He stopped following the communication app that the probate court.
I'm not asking whether there is evidence that he may be apathetic or disengaged or disorganized. I'm asking about the specific issue of depression.
Sure. He, by not following that app, Your Honor, he missed the fact that his daughter was in crisis, had to be taken to, I think, behavioral health network with thoughts of self-harm. He knew nothing about it. He missed the fact that she had fallen and hit her head at a park. Was not aware of that for several weeks. Backing up for a second on the mental health crisis, he also denied that that ever happened. Testimony, something like, well, that never really happened. There was no crisis. When, in fact, mother introduced evidence from the mental health provider that she had seen someone. But also it affected her financially, Your Honor. The appellee hasn't filed taxes in 3 years. He hasn't looked for work in his field, which could He testified that when he's working in his field, he makes $60,000 a year. At trial, he was making, I think, $15 an hour.
The judge acknowledged that in determining legal custody, neither parent was ideal, and each parent had shortcomings. Would you agree with that?
I would agree with that, Your Honor.
And so it was a question not of choosing the clearly the superior, but a question of which parent would do a better job with legal custody.
Yes.
Is it, you say that the father, it's not merely a question of the father not being as good a caretaker as mother, but that he was no longer suitable at all?
That is my first position, Your Honor, that what was going on with him made him an unsuitable caretaker. The depression, but also his lack of awareness of what was going on with the child. He hadn't spoken to the child's mental health counselor in over a year. He didn't know who any of her providers were, didn't know who her pediatrician was.
Well, the judge considered those things.
She did.
Which factor do you think, was there any factor that she was required to consider but did not?
Not on the issue of sole custody, Your Honor.
Okay.
But in addition to that, I would say...
And so which factor did she give so much or so little weight that it rose to the level of an abuse of discretion, which is our standard here?
I would say the depression, Your Honor, and how I've described it in the brief.
The judge found, this is finding 101 on page 59 of the record appendix, that no credible evidence was presented that father has a mental health diagnosis made by a provider. Do you agree with that?
I do agree. I think I mentioned that.
Or that father's mental health impacts his ability to parent the child.
And that, I was contesting that finding, Your Honor.
But you contested it in the trial court. So what we do here is determine whether the trial judge abused their discretion in making the ruling. So you've brought some things to our attention that were also brought to the attention of the trial court who saw the parties, right? There was testimony in this case?
Yes, but I'm saying I consider that a clearly erroneous finding here. As described, that the depression led directly to his unsuitability as a caretaker, along with the other factors that I was talking about previously.
Your brief at page 24 says, father has done naught but ignore responsibility and engage in reckless and otherwise unacceptable behavior. Given the credibility findings that the judge made, I'm not sure I'm seeing how she could have made that such a finding of fact that he's done nothing but ignore responsibility and engage in reckless and unacceptable behavior. She found he was the primary caretaker during his parenting time. He does most of the child's laundry, buys her food, makes dinner, helps her with her homework. She wants to work with him on the harder assignments. They get along well. He takes her on outings they both enjoy. He wants to take her to see an orthodontist and an ophthalmologist. I don't see how that equates with ignoring responsibility and engaging in reckless and unacceptable behavior.
Well, Judge, at least one of those findings I'm saying was plainly wrong, that actually more than one, but...
The one about whether he's the primary caretaker.
Primary caretaker.
You cited a bit of testimony where the preceding week he'd worked 4 days. Does that mean that it's clearly erroneous to find that during his parenting time, generally, he's the primary caretaker?
Yes, I think, well, that and the failure and the finding that he fails to, that mother fails to provide for or fails to take the child to providers. Mother had a plethora of providers for this child, mental health counselor. She sees Shriners Hospital.
The judge didn't find that the mother had failed to take the child to any providers, which is what you say in your brief. The judge acknowledges that the mother took the child, she found, finding fact 127, that the mother facilitates all of the child's medical appointments. It was, the question was whether the mother was going along with the father's desire to take the child to an orthodontist and an ophthalmologist. That's how I interpreted the judge's finding.
Well, the quote is failed to see providers, Your Honor, and I couldn't, aside from the vaccination issue, I hadn't seen anything where she had failed to see providers. She had agreed that the father could take the child to the orthodontist and to an ophthalmologist.
Where did she agree? Where's that evidence?
There's testimony on that point, Your Honor.
Well, there's a finding of fact, finding 138. The judge found father would like the child to receive orthodontic care, including braces, to remedy a gap between her front teeth. Mother did not agree. As a result of the parties' inability to come to a joint decision about the child's care, the child did not get braces. And then the next finding is that father would like the child to go to an ophthalmologist. And then the next finding, 140, says, although mother originally agreed to the daughter's care with these providers, that being the orthodontist and the ophthalmologist, she declined to sign an agreement to that effect, and father interpreted this as mother having withdrawn her consent.
Okay, so that's father's interpretation, Your Honor. What my point was that she did agree, and there was also testimony that she had agreed to allow these services to happen. And I would also point out that these were both of those were preventive care. Not that she shouldn't see these individuals, but it's not quite the same as ignoring the fact that that the child has a mental health crisis. So
my understanding of the record about the child's mental health crisis was that the father said, this is finding 129, he was not certain that the child was actually in crisis because he does not trust mother's reporting, and that father wanted to follow up with the child. Is that inaccurate?
Well, that's his testimony, Your Honor. I won't comment on the accuracy of that or not, but the
judge credits it, right? It's in her findings.
I would say, Your Honor, he didn't know about the crisis because he had locked himself out of the communication app because he had stopped using it for months. And it was his own, what I said before, if you want to call it misconduct, that led to him not being aware of what was happening with the child. So I have questioned the findings about the failure to see providers and the testimony about the finding about father being the primary caretaker. I would suggest it was more than one occasion where he had worked several days a week, and so.
But does that mean you can't be a primary caretaker? I mean, there are a lot of families in which both parents work full-time. Does that disqualify them as parents?
No, but if you're working full-time during your parenting time and someone else is the caretaker.
But the child's in school, right?
Well.
And it was his family, it was his mother, I believe, right, who was caring for the child during those times. His
mother, and pointing back to the unfitness, he was using some unsuitable caretakers. An individual who was mentally ill and another individual who had been cautioned for carelessness with firearms. So his choice of substitute caretakers besides mother was not the best in the world.
I wanted to ask you about the issue of considering the child's preferences
Yes,
in
okay.
the removal
Yes.
decision. Did the mother argue below that number one, that the child had a preference, and number two, that the judge should give some weight to it?
No. This was spotted in the guardian ad litem's report that the child had stated she wants the judge to know about her friends. Is she ever going to be able to see them again? What's going on? That kind of thing. And and by the way, Your Honor, that's the only issue that mother had with the topic of removal that the judge failed to take that.
So was there a clear preference expressed? I saw that in the GAL report, but I didn't see any other evidence that the child said, I want to go to Florida.
That's correct, Your Honor, and it wasn't a statement, I want to stay with my mother, I want to move to Florida. It was more about
I miss some of my friends in Florida, right?
consequences of what would happen if she was denied removal. All right, at this point, if the panel has no further questions, I would just rest on the brief. Thank you.
Thank you for your argument. We'll hear from Mr. Noyes.
Good morning, Your Honors. My name is DUANE NOYES. I'm his father. I've been present since...
Excuse me, Mr. Noyes, why don't you try to avoid using the child's name just to protect
okay.
privacy, okay?
I've been present in his life since day one. I've been an active role model and participant. I've always done what's right for some.
Sorry, I'm going to interrupt you again. Could you please try not to use the child's first name?
Oh, I'm sorry.
Yeah. Okay.
So I've always tried to do what's right for my daughter. I've always worked as much as possible to provide the best life I could for...
So it's really hard not to use her name, but just try to, it's okay.
I'm sorry. So I've always worked as hard as I could to provide for my daughter. I've maintained a steady home for her. She's lived in the same town now for about 8 years. It's the best school district in the area.
And Mr. Noyes, I apologize for interrupting. Is she in school now?
Yes, she's actively
She's going
in school.
to school?
She was withheld from school due to Maria, can I say, do I say appellate?
Yeah, that's
You,
fine.
you
Due
can
to
say
Maria's,
her mother's name. We just
decision.
tried.
She withheld her from school for 3 years, got behind in schooling, and is now in special needs. She's catching up, and I believe within the next year she's going to be caught up. I'd like to not remove her. Ms. Mancuso has had, I think, about 5 different residencies in the last 6 or 7 years, and I don't think that's healthy for her to be bouncing around. I understand that does miss some of her friends and her cat that's down in Florida now. I believe that Ms. Mancuso purposely left that cat down as a kind of a trigger for trauma to make feel guilty about coming back up, as well as the friends. In fact, hadn't talked to any of those friends up until 1 month ago before this court hearing.
The mother herself still lives in Massachusetts?
What's that?
Does the mother herself still live in Massachusetts?
Yes, she does. She lives with her mother's boyfriend. Ms. Mancuso has not had her own place. She's always relied on other people to pay her bills. While I have had to leave a couple of jobs due to Ms. Mancuso's actions, such as when she abducted my daughter down to Florida, I had to give up my job so that I could take time to go down there and serve the court orders in order to get my daughter back. Yeah, that was very traumatic. But as far as depression goes, I'm definitely not depressed. I would be doing better off if I didn't have Ms. Mancuso in my life, without a doubt. But, I mean, one of the things about depression is that in order for it to be a disorder, it would have to have an impact on your life. I've maintained steady employment. It may not have been full-time every year, but even now I work 2 jobs. When on the weekends that I don't have, I work those weekends in order to provide a better life. I've made a lot of sacrifices for her. I would never change that. I love her.
How is she doing? Does she have friends at school?
Oh, yeah, definitely. In fact, she wants to have a sleepover next weekend with one of her school friends.
Just say no to the sleepover. I'm sorry, but
well,
nobody sleeps.
two of her friends came over for like a play date, and now she wants to go have a sleepover for one night at her friend's house. It's not going to end up being a sleepover. I talked with the parents. It's going to be just a play date for the day. But
Try the sleep under. Do you know about the sleep under concept?
no.
They go and they do all the sleepover things, and then you come pick them up, or they come home at like 9 or 9:30.
I like that. That's a good idea.
It's a halfway point.
So how long has she been enrolled in the school?
So she's been enrolled for 2 years. She's finishing up her second year right now. She's in special needs, but she's doing very well. She's a smart kid. She just takes a little longer because she's missed the basics. But as far as like cognitive ability, she's definitely a smart kid. I taught her trig the other day, and she had no problem with it. You know, just teaching her Sokatoa. She's smart. I take it easy on her. I don't try to push her too hard. I let her know that, you know, doing your best is good enough. I do care about her health in other ways too. So I got my degree in biochemistry, molecular biology. I do work actually in the field. I've worked on and off in the field due to, you know, Ms. Mancuso's actions, but I do maintain a steady employment. I don't, you know, have a rich life, but I do get by. I have a nice car. I have a 3-bedroom house. I believe.
Mr. Noyes, I want to ask you about something that the judge said towards the end of her decision. She said, father's ability to make legal custody decisions also requires him to re-engage with mother on Our Family Wizard so that mother can be informed of the child's care and may access her providers and records. Failure to comply with these provisions may constitute a material change in circumstances warranting a future modification of legal custody.
So
do you think the judge's faith that you would, or recognition that you needed to comply was warranted?
No, if you look at the Our Family Wizard text, there's thousands of communications between myself and Ms. Mancuso. What I do is
There were some critical ones that were missing.
So if he's talking about the ones where supposedly had a crisis, I talked to that fact, and it wasn't weeks because I have every couple of days.
What I'm really talking about is not trying to rehash the past, but about going forward. The judge said that you've got to engage with the mother over Our Family Wizard to keep her informed because you have sole legal custody, but you need to give her some involvement.
Yeah.
And the question is, can you do that?
Yeah, absolutely. In fact, Mother's Day was recently. I gave Miss Mancuso Mother's Day, even though it was my day to have her. In exchange, Miss Mancuso was supposed to give me on Father's Day, and she refused to do that. But I did at least give her that on Mother's Day. As far as rehashing the old issues, you know, I believe in modern medical care. Miss Mancuso doesn't. I don't think we're going to see eye to eye on that. There's no point in fighting. If I do ignore Ms. Mancuso's text, it's only because it's an accusation and I don't want to get into an argument about that. But as far as the health care, I had to schedule a visit to the health provider because in order to get her back in school, Ms. Mancuso had to get her seen by a doctor every year. Ms. Mancuso failed to do that, and she was 2 months behind, and I had to schedule that visit in order to get her
why
back
don't we
in
wind up,
school.
if there's a sentence or two you want to say in conclusion, why don't you tell us those?
I think the judge made the right decision. It took her 8 years to make that decision. She just didn't come up with it overnight. She didn't misunderstand any issues or favor me in any way. She made that decision because it was in best interest.
All right. Thank you. Thank you both. We'll take it under advisement. Our second case is number 24P479, Johnson versus Hullbrook. Whenever you're ready, Mr. Uede?
Mr. Uede.
Uede, okay,
Yeah,
thank
David
you.
Uede. Thank you, Your Honor. I'm sure the court is well familiar with the factual record, so I won't belabor it by going into great detail on everything. But, you know, my client's position is that this is a grossly unjust result, and that kind of no good deed goes unpunished. If you look at this is a case of adverse possession involving two neighbors that live next to each other. As we frame it to the court, there are two areas of property in dispute, one this turnaround area and one the area behind it. With respect to the turnaround area, the record is clear that when the appellees moved into their property, there was a discussion between my client and the appellee about giving permission to use the turnaround area consistent with the permission that had been given to the prior owner. The testimony at the time that was in the record at trial was that Mr. Johnson, my client, gave permission to both use, which is very broad, and also permission to engage in parking on the turnaround area.
You know, I saw the testimony from him about parking, but I didn't see any testimony from the other side about parking and being allowed, and I didn't see where the judge found that the original agreement extended to parking. So can you point to where that is?
So I would say that's in a nutshell, Your Honor, the error. If there's no evidence from the other side saying that that did not happen, denying that happened, and there isn't, and if my client affirmatively testifies that is that exactly what he said, the permission that was given, and then the trial court finds, I think somewhat matter-of-factly, that permission was limited, I think is the quote from the very somewhat short decision that was issued. The trial court found that permission was limited, does not provide a factual basis for that in the record, and there's clear testimony again and again and again.
Did the judge have to believe the testimony of your client that said there was an agreement for parking? Because obviously, the more your client can say this was a permissive use and not adverse, the better off.
Well, I would say, being at the trial level, if one neighbor testifies that I expressly said to the person that you may park on the turnaround, and the other person does not provide testimony saying that never happened, Your Honor, and there's nothing in the trial court record to suggest that there's anything wrong with my client's credibility, that he had any kind of memory issues, that he was being untoward or fast and loose with the truth. There's absolutely nothing in the record. So you literally have one side, the factual evidence that is there, you have one side saying, I gave permission for parking. He doesn't say it once, he says it many, 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 many times. He says he saw all the parking. He was fine with it. If he didn't give permission for parking, he would be over there saying, don't do that. But he clearly saw all the parking happening, and he never went over there and complained about it. And then there's zero evidence from the other side saying, no, parking never happened. Never, you know, he never said that. And the court just finding matter-of-factly that one side, you know, just discrediting the testimony and not providing any basis in the record as to why, I think that rises to the level of clearly erroneous. I mean,
So let's assume, just for the moment, I just want to figure out where the edges of your argument are. So
Right.
assume that the permission included both parking and turning around.
Yes, Your Honor.
That wasn't the only thing that was happening on that area, right? There was also a non-fixed, movable basketball hoop that was nonetheless in the area,
Right.
right? The kids played basketball there. There was a horse barn that came in across that area but wasn't placed there, correct?
No, Your Honor. I think what the record shows is, well, our argument is that permission, number one, was very broad. He first gave permission, you may use. It didn't say you may drive up and down. It was you may use this area. You may use it, and that's very broad. In addition, he says you may also park on that area. Included within that use is parking.
So do you think that, is it your contention that the parking permission included a tractor trailer?
Yeah.
Some of the really large things that were parked there? It's not just the family car?
Yes, it wasn't limited to one vehicle. There's testimony in the record that Mr. Johnson said I didn't limit it to one vehicle. They could park commercial vehicles there. They could park a trailer there. They could park vehicles there on this area, and he was fine with that.
How about the oil changes and the vehicle repair? Yeah.
Yeah, I would say that those things that the appellee did with the vehicles that were parked there, it wasn't like he was running a garage there and having a vehicle there stay for years and years and years and years and years. But if there was a vehicle parked there and they changed the oil on it,
It's like the kind of thing you would do in your own driveway, right?
it's incidental to parking. And again, these are neighbors. And this gentleman goes to him and says, yeah, you can use the turnaround area. You can park on it. You can use it. He sees him doing these things. And he says, that's fine. That's all within the scope of my permission. And if you have nothing on the other side in the record where the person doing these things saying, no, he never said that to me, he never did it, and there's nothing in the record to impugn my client's credibility, I would say that's error. And the court doesn't provide any factual basis in its decisions to say why the permission was limited. Doesn't say why. The court just says it, in my opinion, to the court. With respect to the other area in the property, so there's this other area behind the turnaround area. And the evidence in the record is that my client repeatedly testified he never saw the things happening in that area. And
He didn't see the, in the record, there's the photos, and there was so much going on there, right? There's a
Right.
pet cemetery, a nice fish pond, a kennel.
Right.
And a not that very short fence, right? There was a dog kennel,
Right.
and then there was a fence that surrounded it.
Right.
So your client's maintaining, even though there was evidence that he and his wife had gone over on several occasions over the years, right, for various different reasons, that they never saw the fence and the dog kennel and
right.
all the.
I think on this section of the appeal, it's very important to look very, very carefully at the evidence. So if you look at the pictures, so if you look at the pet grave, Mr. Holbrook, the appellee, literally testified he has to rake leaves off it to see it.
Sure.
It's like you can't see it from another yard. It's low to the ground.
The pond and the
The-
dog and the
Yeah,
fence.
So one by one, the pond is also extremely low to the ground. The kennel and the dog is, and the fence around it is not viewable from my client's property. We provided pictures.
That's not the test for open and notorious, right? It's not whether or not, I mean, put aside the fact that you're asking us to overrule a factual determination by a judge who took a view, whatever the limitations of that view may have been. The legal determination for whether use is open and notorious doesn't depend on whether the person who's challenging it could actually see it from their own property.
So I would say, Your Honor, that, and we put this law in our brief, that a couple things. Open and notorious serves to put the record title holder on notice. And to be open and notorious, it must be, quote unquote, without attempted concealment. And to be notorious, quote, a use must be sufficiently pronounced so as to be made known. And that's a case law decided by this court. And so I think here, when the circumstances show that all the photos in the record that we provided from, if you're standing on my client's property and viewing the section of the neighboring property, you can.
Maybe standing in your client's yard, you couldn't see, if we assume that's true. But the reason one couldn't see is because of the trees on your client's property and the poison ivy among the trees.
Yes, Your Honor.
But that was your client's choice to maintain those trees and allow that poison ivy to grow. Could have been cleared away. If your client had walked the boundaries of the property, your client could have seen exactly what was going on in the Hullbrook's backyard. So I guess I'm pushing back on the idea that your client couldn't see this, or clients couldn't see this from their property. It's just they chose to only go in a limited area of their property.
Understood, Your Honor. I mean, those conditions separating the view of the two areas pre-existed the changes that the Holbrooks made. So they made these changes that were very low and could not be seen.
But do you disagree that your clients could have seen this from their property if they'd gone over there, if they'd walked through the woods to look at what was going on the other side of the trees?
Yes, if they walked back behind the Holbrooks property, and these are unique properties, though.
Sorry, so when you said yes, does that mean you do disagree or you don't disagree?
If my clients went and walked on that area of the property, yes, they would.
On their property?
Yes.
So they could see it from their property?
They could see it if they're standing on that portion of their property, but I would say that one thing that the court should consider here is the unique nature of these properties, and this pre-existing boundary with this vegetation existed before the changes were made. And the court did their view in July and then says in their opinion that that you can see this in the winter months, but there was no view done in the winter months, and we provided factual evidence in the record to show that when the court did its view, it did not do any of its view from standing on my client's property, looking onto this other portion of the property where those encroachments had been put on. So essentially, our position is that on the first issue, there was broad permission given, there was permission to use, it was permission to park. All the activities there are consistent with parking. We provide case law. There's actually a case that talks about a basketball hoop where it literally was cemented into the ground, and this is not that. I would submit that allowing a neighbor's kids to play a basketball game with a movable basketball hoop should not give rise to the level of adverse possession where you lose your land. And everything else was consistent with parking. With respect to the other part of the property, I agree. It's not, I think, as strong an argument to present to this court, but it is nonetheless strong in the sense that these encroachments were not visible from the section of my client's property where they lived. There was a natural boundary in place that the Hullbrooks took advantage of. There are only 2 occasions in the record, I believe, where my clients actually went to the Hullbrooks' house. One was to console them on the death of a child, and one was where they went through the side entrance of their house, so you could not see those encroachments from that area. And that should not rise to the level of them losing their land because someone put a low-to-the-ground pet pond or a pond and a pet cemetery and a small doghouse that he couldn't see from his property. I mean, that's tough to lose your land over someone doing those things when you have a neighborly agreement that, yes, you can use my turnaround, you can do these things.
Well, but the neighborly agreement, whatever the contours of it, it did not extend to the use of the parcel behind the driveway, right?
That's correct, Your Honor.
So there's no dispute, and I think that, I mean, I just want to make sure you agree with, or that I'm not reading the judge's decision right. There's no dispute that that part, whatever was happening on that part, was not by agreement.
That's correct, Your Honor. Yes, we're not making that argument. But it's on the factual record before the court, I would just say this is a tough pill to swallow for a neighbor to lose their land over someone doing these, what we would submit to the court, very minor things that are not visible from the portion of my client's land where they live with this natural barrier in place. And to lose their land, you know, after this is...
Would you be here if the Holbrooks hadn't repaved the driveway?
No, and that's the reason. So when they actually did something that was overt that my clients could see about expanding the pavement on the area, my client, for the naked eye, said, "Oh, that looks like taking more than what we allowed you to use." And in the record, you can see they had a conversation. Mr. Hullbrook agreed. Yes, I took it too far. They said, "Okay, well, let's actually kind of look at this neighbor," and they hired a surveyor, and they looked at it. And lo and behold, when they did that, they saw all these other things that they had done back there, and they brought suit to enjoin the pavement. And then the Hullbrooks brought suit saying, "No, we're going to take your entire piece of land." And on the factual record, what the trial court found was they found that permission was limited. I don't think they provided a clear basis for that as to factually how that could be, given the testimony and the lack of testimony disputing that. And on the encroachments, you know, I don't want to keep beating a dead horse, but they are what they are. And to lose your entire parcel of land over that, I think, you know, given the factual record here, is a clearly erroneous finding that we would submit. So unless Your Honor has any other questions, I appreciate you hearing the argument today.
Seeing none, we thank you for your argument. We'll hear from Ms. Carroll.
Thank you.
Good morning, Your Honors. May it please the Court, Maureen Carroll on behalf of the appellees, the Hullbrooks. It would be a tough pill to swallow if it was one, to quote the record, pain in the butt cat that was buried on your property to lose that property. But the argument here would make a grain of sand impossible to become a heap. The Sorites paradox applies to this in the same way that if we were to say one thing here, one thing there, one thing there, does not make for adverse possession. The grains of sand add up to a desert. The grains of sand are the pet cemetery, the fish pond, which on the record, Mr. Johnson says it's different. He has seen it before. It is a basketball hoop, the many basketball hoops that Mr. Johnson on the record says Sometimes it was standing up. Sometimes it was laying down. It was never affixed. He saw that basketball hoop.
And are you contending that kids playing basketball on a movable hoop in the driveway is adverse to the Johnson's ownership of the driveway? Assume for the moment that the permission was, as Attorney Udy says, to park and to turn around.
So we would not concede that, and I would say that
I know,
it is,
I'm asking you to assume it for the sake of answering my question.
if it was one thing and that alone, perhaps, but it was not just one thing. And the permission was not broad. The permission was not implied. Implied permission is,
Okay, but assume for the moment, this is one of the things we have to do as lawyers, right? We have to test the edges of things. So assume for the moment that your client was permitted to turn around and to park on the driveway. What were the activities that your client did that were beyond the scope of that permission, and how many of them were enough? In other words, if it was just the basketball hoop, do you still win?
if it was just the basketball hoop, perhaps not, Your Honor. But it was not just the basketball hoop. From October of 1994 on, the Hullbrooks had a wood-burning stove. They put cords of wood in the turnaround area. The judge found that from 1995 at least,
I
there
thought
was
the cords
continuous
of wood
use.
were behind. So your brief treats the whole, what you call the disputed area, as if it's one area. From an analytic perspective, I find that challenging because there was an agreement as to part of the area. The scope of that agreement is not, your side and the other side don't see the scope of it as the same, but I don't think anybody says there was no agreement about the driveway. Am I right about that?
Your Honor, I believe the record would show that the trial court credited Mr. Johnson's recollection of that conversation, but I believe that on the record, Mr. Holbrook says that he does not recall that conversation or the context or the exact agreement that was come up with as to the turnaround.
So were you contending that the trial judge's decision to credit Mr. Johnson on that point was clearly erroneous?
Your Honor, no, I would not. I would find that.
So let's take that as a given, right? That we have a decision by the judge who heard the parties, took the view, saw the evidence, that there was an agreement with respect to part of the issue that's the part of the land that's now at issue. Considering part of the land that's not at issue as if it's the same is analytically, I think, wrong. So when you say that there were cords of wood put on the area, you're talking about the back lot and not the driveway, correct?
I am not, Your Honor. Per the trial transcript, Mrs. Holbrook puts those cords of wood on the turnaround or at the turnaround.
And they stay there. They're not just there in transit to the back portion?
Your Honor, per the record, per Mrs. Holbrook's recollection, the cords of wood were dropped off and they were used seasonally. And so, of course, it's a wood-burning stove. Those the cords of wood that were stacked do deplete as the heating season continues. But per her testimony, they were at the turnaround. Also at the turnaround was a dumpster that Mr. Johnson felt so
He was
possessive.
crabby about that, right? He called to have it removed.
That's correct, Your Honor. And so the broad use of parking doesn't extend to the use of a dumpster. It would not extend to the use of any non-vehicular use. He says that multiple times on the record, that he never gave permission for non-vehicular use, and that the permission for that turnaround was specifically turning and parking.
Did he address the cords of wood during his testimony by him and Mr. Johnson?
I don't recall, Your Honor.
The judge didn't make any finding about the storage of wood. I see that it looks like Mrs. Holbrook testified about it. Mr. Johnson testified they'd never used it, maybe that they'd never seen it, I'm not sure. But the judge didn't make a finding about whether there had been wood stored there or not, did he?
I believe, Your Honor, that it was part of the entire testimony that the judge heard.
Right, but the judge didn't specifically credit that part or address it in his decision.
It was not addressed in his decision, you're correct.
I wanted to ask, of the many things that you're arguing amounted to adverse possession here, is there evidence that your clients believed they had a right to do any of those things? That they had a right to store a horse trailer or do auto repairs or use a basketball hoop or put in a fish pond or a pet cemetery or a gazing ball or a doghouse. Did your clients believe that they had a right to do that?
I believe that the trial record would show that Mrs. Hullbrook was unaware of the exact property line. I believe that she answers on direct that had she known about that, it may have changed the character of the home and what she fell in love with. And so they did treat that entire parcel of land contiguous from the turnaround to the back property line as their own. They used it against the rights of the true owners, the Johnsons, and they used it continuously from 1994 until the present, well after Mr. Johnson approached them about the paving.
She said that if she had known this wasn't their property, what did she say? Do you recall where that is?
Your Honor, that is in the trial record.
I think page 139 of volume 1 of the trial, she's asked if the Arsenals had mentioned anything to you about an issue with the property line, would you have bought the property? And she says, not without conferring with the other party and finding out exactly what was what, because that would have been very scary to be purchasing a property on somebody else's word. Is that what you're talking about?
That is, yes. And so I believe the trial record and Mrs. Hullbrook's testimony shows that the Hullbrooks treated this entire contiguous parcel of land as their own and cared for it as their own. There is on the record that they brought in a tree removal company to take care of a large oak that threatened to harm a person or property should it fall. There's there's testimony that Mr. Hullbrook took the riding mower to that area, including the turnaround, that he snow plowed in the winter or snow blowed in the winter, and they cared for this. They did clean up, breaking up asphalt over time, leading them to repave the driveway and the turnaround so that it wouldn't continue to deteriorate and possibly cause damage to machines. Mrs. Hullbrook does testify that as a homeowner, they did beautify the land. Beginning in 1995 on, she planted forsythia bushes. She planted a lilac bush. She testifies that she planted 2 peach trees transplanted from a beloved uncle's tree that he grew from a pit of a peach. She testifies that on her anniversary, Mr. Hullbrook gave her a gazing ball that they placed in the disputed area alongside a bench.
I want to ask you about the requirement for adverse possession that it be notorious. And at your brief on page 25, you say that, let me just find here. I'm sorry, page 27. To be notorious, it must be known to some who might reasonably be expected to communicate their knowledge to the owner if the owner maintained a reasonable degree of supervision over his premises. So which of the activities in the back parcel would have been known to someone who might reasonably be expected to communicate their knowledge to the owner?
I mean, well, you have the owners themselves. You have the neighbor, Francis Britt, who testified at trial as well as to being another abutting neighbor and aware of the layout of the land. And you do have the Hullbrooks themselves, who possessed the land adversely against the interests.
It says someone who might reasonably be expected to communicate their knowledge to the owner. That someone has to refer to someone other than the owner, doesn't it?
I would concede that you are correct, Your Honor, in your reading of that.
Yeah. So who was it? This is in the back of the lots. Certainly no one on the public street is going to be able to see that. What way was it notorious?
It was notorious in that anyone who was invited up to that land could have seen it, Your Honor. The Johnsons were invited up to that land to the back of the home. There's no side door, Your Honor. There's a front door and a back door. The Johnsons were invited to the back door.
But the Johnsons' knowledge doesn't count. I thought we just agreed on that.
For that portion, Your Honor, you are correct in that quote. And so that may have been my error, and I do apologize.
Well, I'm not challenging your quotation of the law. I'm challenging how, or asking you to address how it applies here. How does this situation meet the definition of notoriety?
Anyone who approached that land could have seen the improvements. Anybody who knew of where the boundaries lay. Maybe
someone who came onto the back of the land could have seen it, but according to this Foote versus Bauman case that you accurately quote, and quoting a treatise on property, it must be known to someone. Not it could be known to someone if they go on the property, but it must be known to someone who might reasonably be expected to tell the owner about it.
Yes, Your Honor. Had there been anyone, those who were invited onto this property came up the driveway, they saw the turnaround area, they saw the parcel that was used with various uses over time, a bench, a gazing pond, a gazing ball, a fish pond, a kennel. They would have heard the dogs, anyone who came up there, anyone who delivered the barn
Are they
for the
noisy
horses.
dogs? Is there any record of the dogs being vocal?
They're primarily outdoor dogs, Your Honor. There's no record of the noise that they made, but they are dogs, and dogs bark. And they had horses back there, and horses are rowdy as well. They had a swimming pool, they had parties where the Johnsons saw vehicles. They had enough of a sightline to see vehicles lined up and down the driveway and how they parked. Mr. Johnson testified, credibly per the trial judge, as to knowing how the Holbrooks parked their vehicles. He testified as to knowing when there were drips of oil on that driveway. To say that he did not know or could not see the improvements.
No, but this is a different issue again. I want to talk about the driveway separately from the back parcel, because one of those things, there was an agreement, the dimensions of which are obviously contested by both sides, and the other, there was no agreement. I don't think it's helpful to talk about them together.
Very well, Your Honor. I would point out that they were tried together at trial, and the court did hear about the parcels together, and that in the judge's decision, he does discuss the turnaround and the disputed parcel as one. It was not brought up that they should be bifurcated at the trial.
Well, he discussed, and whatever, we can read the decision ourselves and draw our own conclusions. It seems to me that there are separate or at least distinct pieces of the decision discussing each of those parcels.
You're correct, Your Honor. If we were to continue to discuss the intent to conceal portion of open and notorious, the Johnsons were invited up to that property. They were invited up when the Holbrooks were not there. The Holbrooks,
To that property, do you mean to the area with the pool and the pet cemetery and all of those things, or to their home?
they're invited to the Holbrooks' home, and the Holbrooks have said that they used the back door. And so in 1999, when Mr. Johnson was invited by the Holbrook children, when their parents were not home, to address a water emergency, he came up. The Holbrooks did not say, "Oh, kids, don't let them go in the back." There was no intent to conceal. They were invited. Mr. Johnson he saw the children playing in the woods in 1997 and warned Mrs. Holbrook that there was poison ivy. The woods couldn't have been so thick that he could not have seen those boys. He went over there and discussed it then. As of 1997, there was a lilac bush, there was a peach tree, there was forsythia, there was the gazing ball, there was a fish pond. Had he looked, had he done his due diligence as a property owner, he would have seen those improvements, as he would have in 1999, as Mrs. Johnson would have in 2004 when she went to the property to console grieving parents. I would say, Your Honors, in conclusion, that the trial judge did not err. He did not commit any error. He did not commit clear error. He heard 2 days of testimony, 5 witnesses. He went to the property himself. He viewed it. Given the totality of the use, the regular and common and continuous use of this property as the Holbrooks own, I would ask that you affirm the trial judge's decision, deny this appeal, and also, as this appeal was brought on a clearly non-erroneous ruling, that you award costs or any other award as you see fit under Rule 25. Thank you.
Thank you. Thank you both. All right, our next case will be 24P703, Scopa versus Brownstein. This is a partially impounded case, I'd remind the council. Did I? Yeah, it was moved. Okay. Yeah, thank you. Sorry for any confusion over the order of cases here. I've got
That's okay, you just want to keep us on our toes, I get it.
Yeah. Thank you. Mr. Novich,
Yes, it is.
whenever you're ready.
Good morning, members of the panel. May it please the court. I'm Richard Novich. I represent Leslie Scopa, the appellant, in the case before you today. The judgment below should be vacated for two interrelated reasons. The first, the judge abused her discretion by failing to find Mr. Brownstein in contempt, and that conclusion was predicated upon an erroneous interpretation of the parties' separation agreement. As this court is well aware, reported decisions cited in the brief highlight that the trial judge was required to interpret and construe the separation agreement here using basic interpretation principles, such as she was to do so in a manner consistent with common sense and the probable intention on the parties. No words or phrases were to be rendered superfluous or viewed in isolation, and in fact, just the opposite. All words and provisions were to be construed in the context of the entire agreement so as not to render any superfluous or meaningless.
So I want to focus on the words that are at the center of this dispute. And that's, I think, the termination provision of the alimony provision of the agreement. That provision says that the alimony obligation will not automatically terminate upon the husband reaching full Social Security retirement age. To modify the existing alimony order, either party will be required to file a complaint for modification. In your view, or in the position of your client, does that mean that the husband can't retire without seeking a modification?
If you read the entire agreement as a whole, and points I was going to get to, for instance, strike that paragraph A of Exhibit 2. Paragraph A identifies more than just an algebraic formula. It identifies a specific amount of monthly alimony that is to be paid based upon Mr. Brownstein's then existing base salary. You dovetail that into, as Your Honor appropriately identified, paragraph B. The parties very clearly bargained for a narrowing or a limitation on the circumstances under which Mr. Brownstein's alimony would terminate. Death, remarriage, as set forth in the Alimony Reform
So
Act.
in your view, sorry, I just want to ask one follow-up.
go ahead.
In your view, is the alimony obligation expressed in paragraph A of Exhibit 2 unrelated to whether the husband is working or not?
No. No, I believe when you read them all together, if Mr. Brownstein wanted to modify his alimony obligations in general or the durational limits in particular, I believe paragraph E is crystal clear.
So let's say he works until 70, which is, I think, well past the Social Security retirement age, though they keep moving the goalposts on me. Can he then retire and stop paying alimony?
Not before he files a modification and asks for permission.
So you do take the position that before he retires and stops paying, no matter how old he is obligated under this paragraph E to seek a modification.
I don't believe respectfully there's any other reasonable interpretation of that provision in this case.
So going back to paragraph A, it says, husband shall pay wife alimony in the amount of 35% of husband's base salary, and then there's a parenthetical. It's a 35% of husband's current base salary of X is a particular Y amount, 8,247. Doesn't that contemplate that when it says 35% of husband's base salary, and then it explains what his current base salary is, doesn't that contemplate that the base salary is going to change over time? So if it went up, you agree it would?
I absolutely do agree with that.
Should get 35% if it went up. What about if it went down slightly?
So there are two things that are at play with that.
I just want to.
No, that's a fair question. There are two things that, as I view it, are at play with your question. One is if hypothetically he changes jobs, good faith basis, he finds something else, he wants to spend more time with his kids, whatever that might be, he sees something and there's a slight reduction in his earnings. He understands he's got a financial obligation to his economically dependent spouse of some 30 years. That might be viewed one way. In this instance,
So would that be permissible? So would his alimony obligation automatically go down in that situation?
it would. It would. But here's the distinction in this case as I see it. Mr. Brownstein, as the cases that we've cited in the brief, I think overwhelmingly highlight, he had a fiduciary obligation to behave with the utmost good faith to his former spouse. And when you read the...
So I see the argument about good faith and fair dealing, but did you raise that argument, or did Ms. Scopa raise that argument to the judge below?
So
I couldn't
a
find
couple answers to that, Judge. Did the trial counsel come right out and use the phrase implied covenant of good faith and fair dealing? No, she did not. But what she did do was she used other words that certainly addressed the concepts of the implied covenant of good faith and fair dealing in her proposed rulings and her rationale. I direct Your Honor's attention specifically to Record Appendix number 1, pages 337, page 340, page 341, and there may be another.
Can I just ask, so your opponent, the opposing counsel, makes the argument that this case is different in the sense that this agreement merged with the divorce judgment.
No doubt about
right?
it.
And the cases that you cite in your brief, Larson, Kropp, all involve agreements that survived the divorce judgment with independent significance. And so talk to me about that. Is there what effect, if any, does that have on your...
Absolutely. The short answer, Your Honor, is absolutely none. That's an entire red herring. And I would go one step further. As much as I do like and respect my good sister counsel, if you read over her brief carefully, as I know you have, there is no supporting citation to support that claim. The fact of the matter is the cases from this court and from the SJC uniformly say that the basic rules of contract interpretation are to be applied uniformly, regardless of whether the underlying agreement merges or survives. Let me give you a recent example of a case that merged, and a panel of this court specifically applied those very same basic rules of construction. I'm probably going to mispronounce the name, but I'm going to do my best. Talvatai versus Talvatai. It was a 23.0 decision that was decided by a different panel in October of 2024. The agreement in that case merged. The same analysis applied. So when my sister says that because I cited only surviving cases, that's a red herring. There's nothing that I could find in any of the literature or any of the law in Massachusetts reported appellate decisions of this court or the SJC that drew a distinction between how contracts are to be interpreted if the provisions merge versus if they survive. There is no distinction at all. So getting back to the agreement here, the court was to interpret the agreement using common sense, probable intention of the parties, no words or phrases in isolation.
What was it? You cited 3 pages of the wife's proposed findings and rationale, I guess. What was it at those pages, which I just looked at? It wasn't clear to me what you were pointing our attention to.
So the pages in the rationale, I believe Your Honor is referring to the implied covenant of good faith and fair dealing. She makes comments about how the language can't be rendered meaningless. The court is in the best position to construe the language in accordance with justice and common sense. The agreement must not render the party's obligation illusory. Page 341, discussing what was bargained for in particular, namely the alimony would continue past full retirement age. That was very clearly a benefit to the bargain. Husband's interpretation would result in no benefit to the bargain, rendering the language futile. These are all concepts, as I understand it, under the umbrella of the implied covenant of good faith and fair dealing. Now, my sister argues that the case that I cited, Larson versus Larson, which I believe was sometime in the early 90s, in that case, the implied covenant of good faith and fair dealing was squarely before the court. What is unclear to me is whether that concept was raised at the trial court below. There were 3 different iterations of that case.
In Larson?
I'm sorry?
In Larson,
yes,
whether
Your
it was
Honor.
raised? Okay.
There were 3 different iterations of that case that were reported, and in none of those cases was it clear to me whether the implied covenant was in fact raised below. It certainly was an issue in the case, and I believe and I would submit that it's very much an issue in this case. But it's not the only reason why the underlying decision should be vacated.
So in Larson, the husband was not found in contempt, right? I guess procedurally, let me ask this, because both of you mentioned the fact that the husband filed a motion to, or complaint for modification, and the judge, and then later filed a motion to consolidate that with the complaint for contempt. But the judge, interestingly, crossed off, she both allowed and denied and said, see scheduling order, correct? And then in the scheduling order, it says, you know, in February 2024, there's going to be a hearing on the contempt.
Right.
So
is your question, forgive me, I don't mean to be obtuse,
No.
but is your question directed to the Larson case, or is it directed to
well,
the
I guess I'm sorry, I kind of jumped ahead. I guess my question is procedurally, is your position that the judge denied? I mean, she only scheduled the contempt proceeding, right?
That's the way that I interpreted the judge's crossing off of the allowed and
Well,
denied.
she crossed both.
She crossed off both, but the underlying scheduling order
Only says
unequivocally just
contempt.
scheduled the contempt. Had she wanted to consolidate both actions, it would have been very simple for her to say they are consolidated. But the scheduling order says nothing of the sort.
Is the complaint for modification still open?
It is. Yep. But getting back to your Honor's question about the Larson case. The Larson case, I concede, was procedurally different. Larson case dealt with a complaint for modification, not a complaint for contempt here. I can't explain, in looking at the limited record that is available, and the limited record is the reported decisions that have been that I've cited, I can't tell whether a complaint for contempt was even contemplated. But there's nothing in any of the decisions that say a complaint for contempt would not have been an appropriate vehicle, and I can't go back in time, get in the head of the lawyer who represented the complainant in that case to determine why they did not file a complaint for contempt and instead moved forward with modification. I don't believe that that undermines the procedure that we have used here to obtain relief from Mr. Brownstein, if that answers your question, Your Honor. Okay, moving right along. Here we submit that the trial court judge failed to apply the rules, the very clear basic rules of interpretation when applying the parties' agreement. I believe her rationale makes it crystal clear that she read the first sentence of the first paragraph of the alimony exhibit of the parties' agreement, and then essentially stopped reading and read no more. Had the judge read all of the provisions of the alimony exhibit as a whole, as she was required to do, and not in isolation, and applied what this court has referred to as appropriate common sense consideration of the entire agreement, I suggest that three things would have been clear. One, I highlighted a little while ago in Exhibit A. There was a specific amount of alimony that was to be paid based upon Mr. Braunstein's base salary. Two, I don't think there's any question at all that the parties themselves negotiated in Exhibit E, the limitations on when alimony could terminate. And those limitations did not include the circumstance, I believe Justice Hershfang asked at the beginning of this, did not include the circumstance under which Mr. Brownstein woke up one morning and said, you know what, I'd like to retire early.
But I mean, even what if, but you also said, I think, that agreement, I'm going to ask a sentence in English that's actually going to be something you can follow.
I'm going to try to do the same.
I think you also said that paragraph E applied to a time when Mr. Brownstein woke up one morning when he was 70 and decided to retire.
Same analysis would apply.
So he's working for her for the rest of his life until a judge says you can quit.
I take issue with the rest of his life in your question, Your Honor.
Okay.
Let me back up, if I may. Under the Alimony Reform Act, there are provisions that specifically say that the payors reaching full retirement age justifies a termination of alimony automatically.
And they waived that.
They waived that. So, and what they did, they went one step further. And
Now he has to go file a complaint for modification if he wants to.
as my sister, I think, appropriately
All right,
conceded
so
on
we
page
get-
22.
We get your position on that, and that language seems fairly clear. But doesn't that language just go to how long his alimony obligation lasts, not how much that obligation is? I mean, if he had, for health reasons or whatever reasons, wound his work down so that his income was $1,000 a year, he's got to go on paying 35% of that.
I respectfully disagree, Judge. If at the time that he decides to make a change, and whatever that change may be, he decides he wants to make a change, there is very clearly going to be a direct, approximate impact on the economic support of his dependent spouse. If he decides, as in this case, to simply walk away, quit his job, generate no earned income for...
But what in paragraph E goes to that issue? You may have an argument, whether it's waived or not, I'm not sure, about good faith and fair dealing and paragraph A. But what in paragraph E goes to how much alimony he has to pay?
So you can't read paragraph E in isolation from paragraph A. Paragraph A identifies a fixed amount of alimony using a base salary.
That's adjustable.
It is adjustable, but it's adjustable using some good faith fiduciary obligations to his spouse who knows she has a need for the support. I think in this instance what happened, backing up very, very broadly, is that the agreement didn't give him the benefit unilaterally to quit his job, voluntarily retire early, and thereby stop all alimony payments to his spouse. The agreement reached here is inconsistent with the specific provision of paragraph E. Think about it. If he couldn't voluntarily retire, or rather strike that, if his reaching full retirement age, 66 years and 6 months, would not have automatically justified a termination of his alimony, without court approval, he still would have had to get court approval. How is it that, under the judge's logic in this case, she allowed him to retire 6 months early without ever having obtained court approval first? Those two things are inconsistent with one another. He engaged in self-help, and for that reason, which was quintessentially self-help in this case, he should have been found in contempt.
Thank you.
Thank you.
Good morning, Your Honors. My name is Carolyn Van Tyne, and I'm here on behalf of the appellee. There was a lot of things raised by my brother that I quickly jotted down and wanted to immediately jump into, but prior to doing that, I just want to say that from my perspective, from the appellee's perspective, the civil contempt requirements and burden are higher and more stringent, i.e. the clear and convincing standard, as well as the requirement that the elements be a clear and unequivocal order with clear disobedience, because in a lot of ways they're related to criminal jurisprudence. There is an opportunity or a potential that if the defendant is found guilty, he will lose liberty. He will go to jail, he or she. And it is for this reason, and Burchell and in other cases, that they determine that there should be a higher standard, albeit not beyond a reasonable doubt, and that the elements should be clear, just like with model jury instructions, just like with statutes. And it's our position that the judge also held that in this particular contract, the language was clear and unequivocal. Now I'll jump quickly to the contract, because I know that's where Your Honors had some interest relative to the regular alimony provision as well as to the termination language.
Could an implied covenant of good faith and fair dealing ever constitute clear and unequivocal language?
I do not believe so, Your Honor, and I believe that the cases have sort of summed that up. In the cases where there has been evidence that there has not been a good faith, well, let me back up. With respect to whether or not the contract itself is the product of good faith and fair dealing, it's my understanding that with merged contracts, merged separation agreements, when the court accepts that separation agreement and allows it to be merged into the judgment at the colloquy when they get divorced, the judge is essentially certifying that they have found that that agreement is the product of good faith negotiations, that the parties understood it, it was entered into freely and voluntarily. Whether subsequent to the entry of the separation agreement, the fact of someone's engaging in behavior that violates the covenants of good faith and fair dealing results in a clear and unequivocal violation, I think would have to depend on what the language was that was written in the contract. And I know that there's a bunch of...
Do you know of any cases that address whether an interpretation of or an application of the implied covenant could amount to clear and unequivocal language?
I do not know of any case that has said that it could amount to clear and unequivocal.
Or that it could not, for that matter.
Right. I know that there are several cases.
Any case that deals with whether a violation, alleged violation of the implied covenant could amount to a violation of clear and unequivocal language.
I don't know with respect to whether there's a case that specifically uses the term, there's a clear, that there's a violation of the covenant of good faith and fair dealing, and it's not a contempt, but we find as follows. But what I do know, and I think it's cited in both of our briefs, is that many of the cases, specifically that my brother cites, and I'll pull the names, I have them here, but one of the ways that they handle a situation where either they found that perhaps that the agreement is clear and unequivocal, they cannot find a contempt, but that the defendant had engaged in behavior that they felt was not in good faith, albeit they didn't use that term. What they ultimately did was, and I think it's, well, it was Kalaria versus Marks and also Zubik and others, what they said was, with respect to the complaint for contempt, they are not in contempt, but that with respect to record pleadings and record notice, you could, and the judge did, determine that notwithstanding the fact that they were not in contempt, they found that there were attorney's fees that could be owed and that there was an arrearage that could be paid. And what the courts have said essentially is, with respect to the idea that somebody has subverted, for lack of a better term, the intent of the parties, there are other avenues available to a plaintiff, but not a contempt. And that's our position as well. In this instance, there is no lack of good faith. This is a situation where my client worked several years past his original diagnoses, kept adding diagnoses and continuing to work.
Well, we don't really know that because the judge didn't make findings about the health. She found she didn't need to reach that.
That's correct.
And she didn't address good faith either. I mean, I understand your argument that there's no evidence of bad faith, but
that's correct, Your Honor.
And with, finding.
With respect to that, it's more from the standpoint that the argument today had sort of touched upon the idea of he'd
Do you
acted
agree
in bad
that the
faith.
complaint for modification is still open?
I do, in fact, agree that the complaint for modification is still open. I believe it's in the judge's findings. What's interesting, Your Honor, with respect to the complaint for modification is we filed, or my client filed, a complaint for modification. And the reason for that is not an admission that he had an obligation under paragraph A, regular alimony, and I'll touch on that in a second. But in addition to his obligation for regular alimony, he has an obligation for supplemental alimony that has been paid and was acknowledged in the transcript and in the findings. And he has an obligation for exchanging tax returns, and he has an obligation for life insurance. So my client filed a complaint for modification asking for relief from all of those. He also filed a motion, but did not end up arguing it until after he received supplemental income, which was after this particular trial, and so is not before Your Honors today, and ended up paying that supplemental income. But with respect to the complaint for modification, wife then filed an answer and counterclaim, and her counterclaim was exclusively an allegation that my client had engaged in contemptuous behavior by not producing documentation. Later, the documentation was, and we filed a motion to dismiss because you can't do a complaint for contempt as a response of pleading to a modification, and they agreed or was an assented to motion to strike their counterclaim. And there it ended. And so we filed a complaint for modification in August of 2023, and there is no counterclaim. So wife has had almost 2 years in which she could have filed a complaint for declaratory relief if she felt that that was the avenue that she should go.
So it's
she could,
husband's complaint for modification
Correct.
That's still open,
correct.
Not any request for relief, by the way.
Correct. There is no counterclaim. There is no prayer for relief beyond this complaint for contempt. As it relates...
Just a clarifying question. You argue that Larson is distinguishable because in that case the alimony provision hadn't merged. How does that make a difference? Isn't this a matter of construing the agreement?
Your Honor, with respect to the merger versus survival, while I dispute the red herring, perhaps a red flounder, but not a red herring, with respect to the issue with merger versus survival, it's not that the court is going to interpret the contract differently. It is that the remedies available to a putative victim there are more of them. If there is a survived contract that someone is alleging has been violated in some way, and the court determines that there is no violation, the amount of opportunities for someone to be made whole are more limited if there isn't an ability to find that there is some sort of beyond a regular material change in circumstance. And in fact, many of the cases that are cited by my brother, that's in effect what they were saying, is it's not a contempt, these are survived agreements, but we're finding that based upon the other party's behavior, you have now met the burden in order to seek further equitable relief from the court.
So I think at page 37 of your brief, if I read it properly, you agreed that Larson could apply unless the husband's health reasonably prevented him from earning income. Is that fair?
Your Honor, I think with respect to Larson, and I don't have the brief in front of me, but with respect to Larson, our position has been the reason Larson, I understand that Attorney Novich couldn't find evidence of why they didn't file a complaint for contempt, and our position is that they recognize that it's not a contempt, that just because somebody has subverted particular agreements with respect to what the parties had agreed to, but isn't clear and unequivocal, they don't get a contempt, and that's why they didn't file for contempt.
So here's what you say at page 37 of your brief. The court in Larson determined it was reasonable to infer the bargain contemplated husband continuing to work in his profession for the remainder of his normal life work expectancy as long as he remained in good health. His actions, as the court described, evaded the spirit of the bargain. So my question here is the, assuming arguendo that the implied covenant claim was properly raised, is the husband's defense, well, I wasn't in good health and I decreased my earnings for that reason. Not that I have no obligation to reasonably go on working in good faith so that there'll be some base amount to apply the 35% to.
So I think with respect to that question, that dovetails with the idea of this sort of hypothetical that renders the agreement illusory, that what if, in fact, rather than waiting 12 years after the agreement entered to leave once he had been confronted with the health issues, he had left 3 months after? And is that a violation of the agreement or just a violation of the covenant of good faith and fair dealing? And my answer to that would be, and I believe it was in my opening statement, not that it matters because opening statements and post-trial pleadings are not evidence, but with respect, my answer was if that in fact had happened, there could be no finding of contempt. The same agreement would be reviewed, the same language would be reviewed, and
I think we understand your position about contempt. Could there be a finding that the agreement had been violated, though?
no, there couldn't be a finding that the agreement had been violated. I believe what would have to be found was the fact that, and I think some of the cases speak to this, there would be an attribution of income, an order of arrearages, and a declaration that he would have to continue to work at least as to what he was earning at the time that the agreement was entered into, but that would have to be either within the contempt, a finding not of contempt, but a finding that he had to continue, or declaratory relief or modification. I do not think that there is an avenue in which at any point, and I think all of the case law sort of supports that, you could find someone in contempt.
Do you agree that this agreement could be read as imposing an obligation to go on working in reasonably and in good faith, unless, of course, something interferes with that, such as health?
So what I would agree to, and again,
and the question that, and what you're arguing now is really about the remedy and what's available on contempt, not so much about what obligation the agreement could be reasonably read to impose.
No, I don't agree with that. I have said that if you have a hypothetical wherein my client had left his job 3 months after this.
But why does the timing make a difference? I mean,
because I think that speaks to whether or not somebody had the intention at the time they entered into the agreement, and also whether or not it's good faith at that time.
The implied covenant lasts throughout the period of performance. It doesn't just govern you at the first couple months.
No, that's accurate, but at that point, both parties would have the opportunity, well, in fact, the plaintiff would have the opportunity to raise it as an issue, to submit evidence as to whether or not there had been a violation of the implied covenant. And if, in fact, there had been a violation of the implied covenant, the only resolutions that they could seek would be through equity, not through the complaint for contempt.
Why would that be any different if it had been 5 years after the agreement?
Well, again, I think it just depends on the facts at that particular time. But if you read the contract itself, I think it's important for two things that I have.
So in principle, I mean, the application of the implied covenant may depend on the facts at the particular time, but you agree that it imposes an obligation to act reasonably so as not to deprive the wife of the benefit of her bargain that she's going to get 35% of his base income.
I would agree that there are instances where extrinsic evidence is, including whether or not there has been a violation of the covenant of good faith and fair dealing, is appropriate to raise, which immediately would then render the agreement ambiguous because we're now seeking extrinsic evidence, and then I would agree then the court could determine whether or not that had happened and would then determine whether or not there was a remedy.
How is it extrinsic evidence to assume that each party is bargaining for something when they bargain? And then to read the language of the contract as having been bargained for? I mean, in other words, if this provision E means that he can just retire anytime and stop paying alimony, what did she get through this provision?
So what she got through this provision, I'm not necessarily saying what Your Honor is suggesting, but to answer your second question first, with respect to regular alimony and supplemental alimony, she received 35% of all of it. That is a self-modifying agreement, up or down, and it was mostly up. That means that at some point, probably in the mid-teens, the amount of income that my client was earning surpassed what they had earned as an intact couple.
That's what she got through paragraph A.
Correct.
What did she bargain for in paragraph E?
In paragraph E, what she bargained for was that the alimony obligation, not alimony payments, not a base amount of alimony, because that doesn't exist in this contract, but that his obligation to pay alimony would not automatically terminate. That's what it is.
Basically 35% of whatever he was earning.
Would be, well, it would be, yeah, regular alimony plus supplemental alimony, the thing, which would be, again, and to, as I had said to the court, in the lower court, and I'll say it again here, if his only obligation was the regular alimony, or if there were no supplemental alimony, or if there were no issue regarding tax exchanges and life insurance, he would not need, in my opinion, to file the complaint for modification because of the self-modifying nature of this agreement. And to the extent that Your Honor was asking, well, you don't need extrinsic evidence to read intent, but you would need extrinsic evidence to determine whether or not his leaving his job left her disadvantaged. And if you, when you used that extrinsic evidence, determined that it was inappropriate for him to have left his job, then you would have all sorts of opportunities, none of which is finding of a contempt.
Okay. All right. I have to mention one housekeeping matter. The brief is 1.5 space, not double space, and I think if that had been addressed in the certificate of compliance, it might have been noticed, and the brief, I think, is overlong. So try to watch out for that in the future.
I will make, I'm sure we spent a lot of time trying to make it match the amount of pages, and we could have cut it, and I would, if I'd been paying attention, I would have
been appreciated. Thank you very much.
Thank you.
Thank you both for your arguments. Very interesting. All right, and our final case is number 24P375, Paramount MOB versus Tristan Medical Enterprises. Mr. Dunlap?
Correct, Your Honor.
Whenever you're ready.
Good morning, and may it please the Court. Ben Dunlap for the appellants and defendants, Tristan Medical Enterprises and Dr. Ryan Welter. There's a fundamental unfairness that we seek to address in this appeal arising from the eviction and subsequent action against my clients arising from a commercial lease. The unfairness is essentially the application of a rent acceleration clause requiring my client to pay rent through the term of the lease, even though there is or was another commercial tenant in the space paying rent during that same period, essentially resulting in a double recovery by the landlord. I have three principal arguments I'd like to address. First is the enforceability of the rent acceleration provision itself. Bless you, Your Honor. And here, I would draw the court's attention to our brief and the case cited in particular, the Commissioner of Insurance case.
We're familiar with that case. Are you familiar with the 2007 decision of the SJC in a case called Cummings Properties, not the ones that caused the hiccup in this case, but an earlier one, that whereas we modify our holding in Commissioner of Insurance to the extent that where you have sophisticated parties, it may be presumed that the parties intended the liquidated damages provision to apply only to those material breaches for which it may properly be enforced. So in other words, the rule of Commissioner of Insurance that says if you got one bad provision or one bad trigger for default, it invalidates the whole liquidated damages provision. That seems to be no longer the rule.
Well, yes, Your Honor, and I believe we do cite that Cummings case in our brief as well. And for the reason that it was discussed in the 2007 Cummings case, I believe Commissioner of Insurance is still good law for the proposition that when you're looking at, as here, events of default where there are multiple potential events of default, as in Commissioner of Insurance, it's not to say that, and I understand the decision is modified, but we contend the principle still applies that where you have multiple events of default, as in Commissioner of Insurance, and as here, where the default of the performance or observance of any covenant in this commercial lease, and I'm talking about the lease in this case, can result in the application of the rent acceleration. You have covenants in this lease, for example, on maintenance, for example, changing of light bulbs.
Right, and Cummings says that if that's a trigger for a liquidated damage provision, we're going to, that's not enforceable. But that doesn't invalidate the enforcement of liquidated damages where it meets the requirements. So for a non-payment of rent, for example, if that meets the requirements of the two requirements for enforcement of liquidated damages provision, that's still enforceable, even if there are some provisions for some triggers that aren't.
Understood, Your Honor, and I don't think we would have to look at those very highly detailed and completely unrelated provisions like the changing of light bulbs, for instance. But I draw the court's attention to the application in Commissioner of Insurance occurred. The facts of that case were in the lease provision, if the lessee were essentially, if it went into receivership, which is what happened, then that would be the triggering event. And so that for the application of the liquidated damages provision, or rent acceleration. So there, the court was not looking at whether it would apply to the multiplicity, changing light bulbs, for instance. It was a triggering event, an event of default, which would have some relation, perhaps, to the application of an acceleration clause, but it still deemed it unenforceable. For the same reason we say here, the rent acceleration clause in its entirety should be deemed invalid and unenforceable, and then, therefore, the court should have and should apply a credit for the rent paid by this successor tenant, OCPN, for the period that OCPN occupied and paid rent during the remainder of the lease term of my client. The second argument that we raise actually goes to the question of what lease language is actually applicable. And the reason for that is that the record makes clear that even though there is a May 2017...
If I understand properly, what you say is missing is the First Amendment dated May 31, 2017. And I just want to make sure I understand your argument.
I'm sorry, I didn't mean to interrupt you, Honor.
There are two documents that are missing. One is the First Amendment dated May 31st of 2017, and the other is the amended and restated lease dated September 29, 2017.
Thank you, Your Honor. I don't mean to imply that the first of those that you just mentioned is missing. It is in the record.
Where is it?
I'm sorry. That is in the record. It directly follows the.
Is it 593, Record Appendix 593?
That's correct, Your Honor.
And what about the second one?
The second one, you are correct, Your Honor. It is the amended and restated lease dated September 29, 2017. And that document is not in the record. It was not introduced by the plaintiff who bears the burden in the breach of lease agreement. It was not introduced at trial or at any point in the underlying proceedings. This was raised by my client in the pretrial memo. That's at Record Appendix 44. It was raised again in the post-trial brief. That's at Record Appendix 693. There was testimony referring to this document. My client specifically testified, this is Record Appendix 349, specifically testified that there was a restated, amended lease and that he didn't have it. So
was a question raised about whether the liquidated damages provision was any different than what was in the original?
We don't have that in the record, Your Honor. We don't have whether.
But I'm asking whether a question was raised about it.
I didn't.
Because it seems to me that if you want to make an issue of this at the trial level, you've got to say not only is this not in the record, but we have reason to think that the provision is different, and so the provision they're trying to enforce is no longer in effect.
I think I'm sorry, Your Honor, I didn't mean to interrupt.
Okay, go ahead.
My understanding of the state of the trial record is there's simply no evidence about what, if any, liquidated damage provision exists in that amended and restated lease. I did not see a question in the testimony, in the transcript, specifically asking any witness what that document says. I believe the testimony, the state of the evidence is that there is a document that's controlling. It's a controlling instrument that controls the obligations and duties and rights of the parties, which is not before was not before the trial court. And so at a minimum, the trial court would have needed evidence that there was an enforceable liquidated damages provision in that amended and restated lease.
Where at Record Appendix 44 is this particular issue raised? I see defendants raising 5 significant issues there, and I'm not clear that this falls under any of them.
It's in number 3, Your Honor. Whether subsequent agreements relating to the defendant's giving up his leasehold estate abrogate conditions initial lease. I acknowledge, well, it says what it says, Your Honor, and we contend that that is the defendant referring to a subsequent lease, in other words, the amended and restated lease agreement.
But that's relating to him giving up his leasehold estate. It doesn't seem to be about the liquidated damages provision or his obligation to pay rent.
Your Honor, does not specifically refer to what, if any, provision may be controlling in that subsequent agreement. If I could turn to my final argument, Your Honor. This is the trial court's post-trial determination in a post-trial memorandum or an order on the post-trial briefing. a finding that my client was, quote, sophisticated. Sophistication of the lessee is an element.
Wasn't there stipulation, though, in that he was, in fact, well-versed, in fact, on Record Appendix 88, paragraph, I believe it's 11?
We contend there was no stipulation, Your Honor. The appellee in the briefing does refer to the documents submitted with summary judgment motions. Is that what Your Honor is referring
yeah.
to? And so we would contend, first, the language used in the statement of undisputed facts was not as to sophistication. It merely said that
This is paragraph 10, Welter, Tristan were experienced in real estate transactions and negotiating leases. And furthermore, wasn't there testimony, evidence that Welter had experience in negotiating leases, and he was knowledgeable about common area maintenance rates, recruited tenants to the building, participated in marketing the building, developed the tenant mix, directly negotiated the lease for Tristan?
Your Honor, we have two points on this line of argument that the appellee has raised. First, yes, we acknowledge there was testimony about the level of experience or the types of experience that my client had with commercial leasing. We contend that actually helps our side because specifically in the testimony at trial, it was shown that he was not sophisticated. He had been managing the leases in this property in a way that the principal of the landlord described as a mom and pop kind of operation. This was contrasted with the type of sophisticated leasing and management that the landlord brought in when he came to the building. There was testimony that in contrast to my client in dealing with the sale of the building and then subsequent rental and leasing to commercial tenants, that the landlord needed to bring in a, quote, sophisticated broker. I think the contrast showing that my client was not a, quote, sophisticated person in dealing with tenants and lessees. And so we would contend first that the testimony showed that although he had some experience, and we do acknowledge, of course, that in the summary judgment record it was stated undisputed that he had experience, but the experience is not the standard, it's sophistication. And second, our objection is that the judge made this determination or these findings of fact in the absence of any request by the parties that the trial court do so. It was not, there was no request.
The judge seemed to be saying, you know, in reading these Cummings cases, I realize that the lessee's sophistication is a relevant issue. I forgot to address that in my findings after trial. So I'm going to make the findings now. Is there any problem? In fact, isn't it desirable that if a judge realizes he's made a mistake and left something out, he remedy it while there's time? I mean, it didn't seem to me he was relying on any of the evidence that, or any of the materials that had been submitted with the 60B motion. It's just relying on trial evidence.
Well, the trial court did not cite to any particular evidence in making that finding, and we contend that's part of the problem with making findings in an order on post-trial motions where the findings are not requested. There's no request for evidence on that point, and the judge made these findings.
Well, I mean, I'm looking at page 738 of the record appendix. The judge has a paragraph about why, the basis on which he's making these rulings, right? Dr. Welter was the previous owner of the building. He was the owner who sold the property to the plaintiff here. He was very familiar with commercial leases, common area maintenance charges, and other charges common to commercial leases. He had also previously owned other commercial, but, you know, he says a couple more things. So are you contending that those facts are not in the record?
Some of them are indeed incorrect, Your Honor. For example, the contention that he owned the building, that the testimony was not that he owned the building. The description in the testimony was he was some sort of agent for the owner, but he was not an owner. So we contend that by making findings in this way, it was an error for the trial court to do that.
So what if we agreed with you on that one point? What would the remedy be?
Well, it would be to vacate the judgment, Your Honor, because
The
again,
whole judgment, not just this after-the-fact finding of sophisticated party?
Your Honor, sophistication of the parties is an element, a required element that the plaintiff has to prove to demonstrate, to meet his burden for, under a breach of contract claim to apply the
Liquidated damages.
the liquidated damages provision.
Was the amended and restated lease requested in discovery?
I do not know that, Your Honor.
Okay. The pretrial memo doesn't identify any outstanding discovery disputes that I can see. Okay. Thank you.
Thank you, Your Honor.
Can I speak to that last?
Mr. Prue, you absolutely may.
Nice to
Whenever
see
you're
you.
ready.
Thank you. Can I speak to that last statement? It, in fact, was requested. In his deposition, you'll find the supplemental index. Supplemental index indicates that he was asked a specific question, that a document had been produced which was unsigned, and the question was, where's the signed document? Has it been signed? I think so. I don't have it. Maybe my attorney, who at the time was his attorney, has it. Will you go seek that and provide it to your attorney? Yeah, I will. Never done.
So this is the amended and restated lease that you're referring to?
Yes. Yes.
And is that deposition testimony in the record?
It is. Supplemental exhibit, supplemental appendix. Okay. And I want to go a step further and talk about how this matriculates through the process. So the fact is, this lease, and I want to talk broadly about this lease that was enforced under the terms of the decision by the Superior Court, was the lease that was used and relied upon in a summary process action in Taunton District Court. There was no objection to that lease as an operative lease at that time. Secondly, that lease was the only lease that was discussed during the summary judgment in the Superior Court on monetary damages. In fact, if you'll look to the stipulated facts, you will find that there is a record of what the default provisions in that lease, agreeing to what the lease said. And I can get you that specific.
Yeah, Record Appendix 40, the pretrial memo, quotes the liquidated damages provision.
It does, but it goes further than that. There is a the stipulation itself says in 5 places on summary judgment. So when you oppose a summary judgment, you're supposed to put all the facts in evidence that are agreed upon. And the statement of undisputed facts, I believe, starting at number 20 on the statement of undisputed facts.
Starts at number 5, actually. 5 is Tristan Medical Enterprises was a signatory to a lease agreement with plaintiff as landlord dated May 15th, 2017, and a first lease amendment dated May 31, and that's admitted. And the next one is the same, basically, for Mr. Welter, Dr. Welter.
Right. Then you just go to 20 where we start talking about the operative lease. At 20, it starts talking about what the default provisions of the operative lease say. And that was the basis in which all parties proceeded on summary judgment, and it was allowed on summary judgment. At trial, that was the only lease that was introduced. So everybody still relied upon it at that period of time. So it's been the only lease that's been in evidence in the whole case. And it was relied upon by all parties. And to suggest that there's another operative lease out there, he had the opportunity to provide it in the discovery process. I also suggest to you that if he doesn't provide it, and it wasn't, but Rule 37 allows for the disqualification of that type of document that isn't provided during discovery. So there's no reason to raise it because it was it didn't exist, I mean, as far as we know. So that kind of sums up that particular document. In terms of the sophistication, I want to remind the court of the more recent Hines decision, 2023. The more recent Hines decision doesn't talk about perfect sophistication. In fact, I think comparatively, Dr. Welter was far more sophisticated than Hines was in that particular case, in that he owned the building, or he had an interest in the building, I think is how it was termed. It was actually owned by Sky Enterprises, and Sky Enterprises, by the way, owned by his wife. I think he admitted that at trial. So, and it was built in 2005, and he acted as the manager de facto for the building. So not only does he have this general experience, but he's got very particularized experience in this building, in leasing this building, in an understanding of building operations. So I don't think that this is suggesting that he's unsophisticated. Maybe he did a bad job. I think that was ultimately the testimony of the plaintiff. He didn't operate it correctly, but that doesn't make him unsophisticated. I think he said he testified to having other interests too. So, I mean, he was a de facto business person who understood the sophistication of building operations. And then in terms of the issue being raised by the judge about sophistication later, it was my brother that invited a post-judgment motion, which the court acted on wisely after the second Hines case came down, was able to determine what findings should be and may be appropriately in this sort of a decision, and he made those findings. And those findings were invited, and that's part of Rule 59 allows you to do that. It certainly allows you to provide that type of information or supplemental findings. So it was invited by my brother's firm, and that's what the judge did. In terms of the damages, I think that just briefly, I think the nail right on the head with the commissioner case, that in this particular case, the judge listened carefully to the evidence and parsed it appropriately. He said the 10-year lease was for the benefit of my client, the plaintiff and appellee, and that he could not reach back and grab those, although extraordinary circumstances when this was a medical office building that had to be retrofitted. There's extraordinarily expensive buildings, to do that. But the judge says, I don't see that as offsetting, as the plaintiff should benefit from that, or the appellee in this case should benefit from that. And he said, but the liquidated damages was clearly negotiated between sophisticated parties, and there was no suggestion that it was unfair on its face, or that they could have understood exactly what the circumstances of the of damages would have been when it was negotiated. So I'll take any questions.
Any questions? No? Seeing none, we thank you for your argument. Thank you both.
Thank you.
We'll take the case under advisement. That concludes our sitting for today. I want to thank our court officers, our clerks, and our clerk's office staff for their assistance. And with that, we are adjourned.
Would all rise, please. Court is now in